This is Michael Popok. It's time for Legal AF After Dark, the 3 co-anchor edition. Ben Meiselas, Karen Friedman Agnifilo, and me. We get together, and this time we're talking about, as you'll see on the next clip, what are the next steps now that it's in the hands of John Roberts, Chief Justice, with Donald Trump's attempt to have his D.C. election interference case have it dismissed, have the indictment go bye-bye because of absolute immunity. He already lost at the D.C. Court of Appeals. He didn't get a chance to take it to the full D.C. Court of Appeals. Will that matter to the Supreme Court? Will John Roberts send it back to the full group of 9 to see if there are 4 votes to decide whether to take the appeal up at all, or will he leave undisturbed the D.C. Court of Appeals decision against Donald Trump, finding that there is none and never will be presidential immunity for criminal conduct that's committed by a person who occupies the Oval Office while president, and the indictment stays exactly where it is. We give you our best analysis at that intersection of law and politics. Take a listen.
All right, let's just switch gears, though, very quickly, talk about what's happening with the United States Supreme Court. Just as a refresher, in the Washington, D.C. federal criminal case against Donald Trump being prosecuted by special counsel Jack Smith for Trump's attempt to overthrow the results of the 2020 election, Donald Trump asserted absolute presidential immunity in a motion to dismiss the indictment. Federal Judge Tanya Chutkan denied Donald Trump's motion to dismiss in early mid-December. Donald Trump then appealed to the D.C. Circuit Court of Appeals. That interlocutory appeal stayed the proceedings before Federal Judge Tanya Chutkan. There was oral arguments that were held before the D.C. Circuit Court of Appeals. They finally reached a ruling affirming what the district court did, in other words, rejecting absolute presidential immunity. And they gave Donald Trump until February 12th to go seek a stay of their mandate from them sending basically their order to the district court for the district court to resume proceedings. They gave Trump until February 12th to seek this application for a stay pending an application for a petition for certiorari, in other words, the actual appeal on the issue. They gave Trump until February 12th to do that. Trump waited until February 12th and filed this application for a stay with the United States Supreme Court. Trump didn't file with it a petition for certiorari, which would be saying, we want you to actually hear the issue of absolute presidential immunity. What Trump filed was, please stay all of these proceedings, keep the district court paused, delay. It would take 5 Supreme Court justices ultimately to vote in favor of an application for a stay, for the stay to be in effect. The Supreme Court, through Justice Roberts, gave special counsel Jack Smith until February 20th to file a response. Special counsel Jack Smith had a response ready within 48 hours, filed a response saying that there should not be a stay and just to send the case back to the district court. Supreme Court, you shouldn't even hear this on certiorari. Why? Special counsel Jack Smith says, because we tried to bring this issue to you back in December. Remember when the government did that on an expedited basis? Well, you rejected it then, so you probably don't think this is an issue that you want to even hear. And in any event, there's been a new development since December, which is the D.C. Circuit Court of Appeals made this bulletproof, appeal-proof, 50-plus page ruling. So Donald Trump has no prospect of success in the Supreme Court reversing what the D.C. Circuit did. So read what the D.C. Circuit did. You have to apply the standards. 1, a likelihood that you would grant certiorari in the United States Supreme Court. 2, that there's a prospect of success. And 3, you have to balance the equities. If you apply those factors, there should not be 5 votes on the issue of this application for a stay, this delay being sought by Donald Trump. But special counsel Jack Smith says, look, I do kind of get that I brought this issue to you in December, which, I hear you. We said it was a fundamental issue then, even though there were these new developments that have since emerged, like you rejecting it and the D.C. Circuit affirming what federal judge Tanya Chutkan did. So if you do want to hear it, let's not do a delay. Just convert Donald Trump's application for a stay into a petition for certiorari. set oral argument on the issue of absolute presidential immunity for sometime in early to mid-March, and let's just expedite this and get the show on the road. Then Donald Trump's lawyers filed a reply, even though I don't think the Supreme Court requested one. And the main argument by Donald Trump's lawyers were, look, this is kind of disingenuous by special counsel Jack Smith, saying that you shouldn't stay this and that you shouldn't grant a petition for certiorari when special counsel Jack Smith requested you do so back in December. While kind of ignoring the thrust of special counsel Jack Smith's arguments, though, that, look, there's new data. Supreme Court, you rejected it when we requested it. And two, we've got the D.C. Circuit Court of Appeal ruling. So send it back to the district court is what Jack Smith is arguing. The Supreme Court meets on Friday. They have a meeting. They convene with the justices. So I think they probably met, and Harry Littman, who I did a hot take with, who used to be a top official at the DOJ, he believes that they met the 9 justices on Friday. So I would expect really any moment now, as early as Monday, Tuesday, Wednesday. I think no later than this upcoming Wednesday, we will hear if the Supreme Court will grant an application for a stay. It takes 5 justices to grant the application for a stay. So if you got the 5 votes for a stay, I think you'd have the 4 votes to then grant a petition for certiorari, which is why Jack Smith said then just convert the stay into the petition, grant a petition, set the hearing so we can have that oral argument. Y'all remember the oral argument with the 14th Amendment Section 3 case. Jack Smith it's basically like that same type of oral argument. Just set that for March. Let's get the show on the road if you're eventually going to grant certiorari anyway. So we're waiting to hear what the Supreme Court does there. As early next week, we could hear the Supreme Court basically say they're not going to grant a stay and send this thing back to the district court, and proceedings will get back up there, which they've been stayed since, early to mid-December before federal judge Tanya Chutkan there. Or they could possibly say we're going to grant a stay, and they'd probably then say we're going to grant the petition for certiorari and set oral argument, in which case the matter would remain stayed. But I'd expect an oral argument to happen more in that kind of March, mid-March, late March, potentially early April period, but we'll have to see what the Supreme Court does. Ultimately, all of that affects the timing of the other criminal case, the Washington, D.C. federal criminal case, and how soon after the Manhattan District Attorney case will the D.C. case go. One other just kind of note as well that, Judge Eileen Cannon granted, I thought, an interesting order this week, because I think she's still going with a bit of the farce that her trial scheduled for May 20th in the Mar-a-Lago document case for Trump's willful retention of national defense information. She actually issued a paperless order ruling against Donald Trump here, denying Trump's motion to adjourn certain pretrial dates and deadlines. But she made it super confusing also with some clarification that depending on her ruling and the motion to compel, Donald Trump can kind of revisit the issue with some motion eliminates at a later time. I mean, it's just a very confusing ruling. I think Judge Cannon and probably the parties are confused what she's even saying there too. But I think she's going with this idea that she's still keeping this May 20th, 2024 trial date, which makes absolutely no sense given she hasn't set other dates and deadlines that are going to take time for her to resolve. So I don't believe that May 20th, 2024 deadline is real at all. And I think if the Supreme Court does not grant Donald Trump stay, I don't think federal judge Tanya Chutkan's going to even care that Judge Cannon has that May date. I think Judge Chutkan's just going to set her trial date and say, well, we'll see where things are at that time. One other or two other just kind of interesting, kind of geek out with the United States Supreme Court things that I think are worth sharing. Remember the Blassingame case that we always talk about, where the D.C. Circuit found that Donald Trump doesn't have presidential immunity in a civil context? Donald Trump did not seek certiorari there, and the deadline has now passed for Trump to challenge the D.C. Circuit's opinion in Blassingame. He could always revisit it later in the case on a summary judgment or after a verdict, but he is not filing a petition for certiorari there. And then also the United States Supreme Court has set oral arguments in that United States v. Fisher case, which is challenging the issue of obstruction of official proceedings counts. It's not a case that directly involves Trump, but two of the felony counts against Donald Trump in the Washington, D.C. indictment involve obstruction of official proceeding, and the insurrectionists have been challenging the Department of Justice's ability to file against them using that charge or using that claim, and it's worked its way all the way up to the Supreme Court. Oral arguments there will be in April, and that's a big one because if they find that obstruction of an official proceeding is not a viable claim to be brought by the Department of Justice, it could potentially impact 2 of the 4 counts against Donald Trump. So that kind of focuses on our Supreme Court review. I want to toss it over, though, to, I mean, Michael or Karen, if you have any other comments there. If not, I want to kind of finish the show.
I just have one. We'll know soon whether John Roberts has the ability to drag 2 more people over to his side and affirm the D.C. Court of Appeals by rejecting the state petition. In order for the 5 that you talk about to take up the case and then ultimately rule on the merits of the case, there has to be 5 votes that there's a fair prospect that the justices will permanently overrule the lower court. I'm not sure about that. If John Roberts wants to leave undisturbed the D.C. Court of Appeals, he has to find 2 out of 3. And of the 3, he's got to find Kavanaugh, Amy Coney Barrett, or Gorsuch. And I think he's more likely to try Gorsuch and Amy Coney Barrett. Kavanaugh and Amy Coney Barrett, because there's just people that are just not going to vote against Donald Trump, which are Alito and Thomas. If you can find those 5, and they find that it's not fairly likely that they're going to overturn, then this thing dies right here. We don't need all that extended briefing and oral argument that you've outlined. But if John Roberts, who only in rare occasions have I seen him, exercise, make this the Roberts court and really take control here. If he doesn't, then you're right. We're going to be on the normal track of briefing and appeals in March, and then again, hopefully, if the case on immunity dies. And my understanding, I'll leave it on this, my understanding from reporting has always been that Donald Trump and his own lawyers don't believe they'll ever win on immunity. Let me repeat, Donald Trump does not believe he's going to win substantively on the appeal he's making. This has all been a tremendous elaborate game and stratagem for delay and delay's purposes only. They think at the end, once this dust settles, this plane lands, that they are going to lose. It's just when are they going to lose? And if they can get it over the hump of November, that's what they've been trying to do. Let's see if John Roberts is going to be an accomplice to this stratagem or not. Well, if you like legal shows and politics shows where the lawyers know what they're talking about, you've come to the right place. One place only, the MeidasTouch Network and Legal AF. The title is exactly what you think we do, what you just saw there. Every week, twice a week on Wednesdays and Saturdays at 8 p.m. on this YouTube channel, and then on audio podcast platforms of your choice. If you're part of our audience, thank you for being there. We really appreciate you making our journey part of yours. If you would, and if you know people that would be interested in Legal AF, that's a good way to send them that little appetizer, that little clip right there. Send it off to them and say, hey, that show Legal AF I love? Come, take a listen. If you like it, join us and join our podcast. If on the other hand, you have no idea what I'm talking about, I invite you to join our audience. We do that at the intersection of law, politics, and justice, not only those Wednesdays and Saturday podcast recordings, but we, the leaders of Legal AF, and you just saw all 3 of them, we bring you our analysis and updates in individual hot takes about every hour on the MeidasTouch Network. So we invite you to join our audience if you so please. So, until my next hot take, I got a little excited there. Until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.